Quick divorce under the Indian laws is the mutual divorce, which is on the basis of mutual agreement between both the parties, which includes that the husband and wife agree mutually to get their marriage dissolved. On records, a mutual MOU is created, agreement is created, and a settlement is created, any kind of document which stipulates all the terms and conditions, on what conditions the marriage is going to be dissolved, if there is any exchange of property, stridhan, maintenance, and all other aspects related to this marriage are recorded there, and it is guided that who will take the first step and how it will be initiated. This is done by this is very important document, and it should be done by a very expert and a very seasoned lawyer who can visualize all the eventualities, and the custody of minor children if there are any, and who is going to keep the custody of the minor children, who is going to pay for the upbringing, and all other related issues are mentioned in this settlement. If there is any ongoing litigation, that has to be mentioned, and it has to be mentioned that how you are going to resolve that ongoing litigation, whether you are going to withdraw it or compound it, if there is a fire quashing involved, how it will be done, who will initiate, and what will be the timelines. All these things are required to be written very clearly. And once the MOU is made, we call it MOU, sometimes it is agreement, sometimes it is settlement, it can be any document. On the basis of this, then the divorce petition is prepared. The divorce on the grounds of mutual consent is provided under section 13B, subsection 1 and subsection 2 of the Hindu Marriage Act, which contemplates two motions, and also under section 10 of the Indian Divorce Act. Hindu Marriage Act controls and regulates the divorce between Hindus, and the Indian Divorce Act regulates and controls the divorce between Hindus as well as all non-Hindus. Practically the provisions are same, only one difference is that in Hindu Marriage Act, once you are filing a mutual divorce petition, then you will have to show that you are residing separately, you have not cohabited with each other. Under the Hindu Marriage Act, you will have to mention that you are residing separately since last 1 year and you have not cohabited as husband and wife. Under the Indian Divorce Act, it has to be mentioned that the period of separation is 2 years. That's the only major difference between both these acts. Rest procedure is practically same. Once the MOU is entered, you will prepare a petition, then affidavit is attached, you will specify everything in the petition, and this agreement will be a part of your divorce petition. So first motion is filed under 13B1 of the Hindu Marriage Act and section 10 of the Indian Divorce Act, and your photograph, your proof of identification, if there is a marriage registration, marriage photograph, proof of identification, your address proof, all these things are filed, and then within 2-3 days it comes up for hearing before the court. Court will seek your presence, you are required to appear before the court. We know that it is filed before the family court. The judge will ask some formal questions, and your statement is recorded, your signatures are taken, your thumb impression is taken, then in some courts joint photograph is also taken, and your first motion is accepted. Once it is accepted, after 6 months of acceptance of first motion and before expiry of period of 18 months, you can file the second motion. And in the second motion, same procedure is again repeated. Only variation is that you will have to mention that during this after the first motion we have tried to reconcile and there are no chances of reconciliation, it has failed, so the marriage should be now dissolved and we have not cohabited as husband and wife during this period also. So this amounts that the marriage is now to be dissolved, and on the basis of this statement in the second motion it is accepted, and the court passes a decree of divorce. There are two clarifications which most of us get queries. First is how to write this separation of 1 year before filing of the divorce petition in Hindu Marriage Act, and 2 years before filing the mutual divorce petition in Indian Divorce Act. Now the law has been redefined, and even if you are not residing separately but you are residing in the same house, you can claim that we are residing in the same house but we are not living as husband and wife, we are residing in two different rooms, and on the basis of that you can show that there is a separation. In most of the cases we find that parties are already separated, they live separately, so that period is easily counted, and that's on the basis of your statement. There can't be a document, there is no document, generally there is no document, so court believes it, and on the basis of this court accepts your statement and records it. Now there is another misconception that the mandatory period of 6 months, that is the statutory period, cooling off period, which is required after first motion and before filing of the second motion, is waived off and has been waived out by the courts. That's not the true fact. It has been waived off in some of the cases, and now the court has said that it is not mandatory, it is rather directory. In some extreme cases, when the parties are already fighting with each other since last so many years and there is no chance, the fight is bitter, there is no chance of reconciliation, the courts say that now there is no chance of reconciliation, and since the parties are fighting since so many years, this period is waived off and both the motions are taken in one go. This is the law, and let's be very clear on this. This is ordinarily, generally it is not waived off by any court. So there are number of reportings in media in this regard which are all practically misleading, and based on that people approach us saying that we want a waiver of that period. That's not possible, that's not the law as on date. Another aspect which most of the people ask is whether I can file my divorce on the basis of, somebody can file the divorce on attorney or special power of attorney if I am not in a position to attend, if I am NRI, I am residing outside India, or if I am not in a position to come, can I issue a general power of attorney or special power of attorney, and on the basis of that my father, my brother, my sister or any close relative can appear before the court on my behalf and make a statement. Now this, since last few years this procedure has been accepted and courts are accepting it, and now since the hearings are happening virtually, so it's more easy now and it is very much possible, but then you will have to explain, give a very good sound explanation that how and why you are not in a position to come before the court. Once you explain it, court will accept it, and the divorce can be on the basis of general power of attorney or special power of attorney issued by any of the parties. But generally it is not possible that both the parties are not there and their SPA holders are appearing before the court and making statement. That's very rare and it generally does not happen. Now another aspect which most of the people ask us is what is the fees. So far as the court fees is concerned, it is few hundred rupees depending upon the states, and court fees is limited to these few hundred rupees, and the fees of the lawyer depends upon the stature of the lawyer, your paying capacity, the comfort you are looking for, the services you are seeking from the lawyer, because these things are very complicated and they have very far reaching effects. So it is always good to have a very good lawyer, very seasoned lawyer who can comprehend all these things and make you enter into a settlement based on negotiations, and who can visualize all eventualities of future like the property distribution, the passport, the nomination, the stridhan, maintenance, custody of children. So many issues are involved. So it's always better to have a very good lawyer to take up all these things, and the fees can be from few thousand rupees to few lakh rupees as per your comfort, as per your paying capacity, as per the stature of the lawyer which I said. Now this is the easiest form of divorce under the Indian laws, and mutual divorce is nowadays accepted, and courts are also there granting mutual divorce on the basis of consent.